so let me introduce the panel. We'll go from your left over to right, and I will also invite you to introduce yourself further so that people may know a little bit about your technology background, where you primarily work, and so that they can understand where it is that you're coming from, your point of view. But we have John Hocker, and he is the founder of Cybernetic Law PLLC, and he is a patent attorney and a former examiner. So we can get both perspectives from John. And then we have Wen Z, and she's a partner at Global IP Counselors, and she also does a vlog for us on IPWatchdog, so we're happy to have her here. And one of her articles is among the materials that we have online for this. Next to Wen we have Carrie Sicard, and she is a patent attorney at Virtual IP Law LLC, and she's a graduate of the school formerly known as Franklin Pierce Law Center, which is my alma mater as well. So thank you for coming from New Hampshire. And last but certainly not least is Keith Fredlake, and he is a member of Cozen O'Connor. And we are going to have this conversation and try and talk about secondary considerations, but also talk about obviousness more generally, which I personally think is a mess, and we just don't even know it yet. Because I think what we are going to see is once the 101 stuff gets sorted out, then we're going to realize just what a mess 103 still really is. So let's go in inverse order. Keith, we can start with you. Okay. And what are your preliminary thoughts on obviousness and or secondary considerations that you'd like folks to know?
Okay. Yeah, so I'm Keith Fredlake. I always tell people I'm a backwards patent attorney, which means I went to law school, discovered there was something called patent law, and said, hey, I like that, but I didn't have a technical degree. So I had to go to do a technical degree after law school, which was really fun to do. And then I see that Kathy Vidal reduce the requirements to now take the patent bar for those types of people. So now I'm a little bit upset that was requirement to reduce, but happy for future lawyers that find themselves in that position. And so I'm kind of always excited about secondary considerations, because the number of times I prosecute applications I draft is 1 in a million. I always prosecute an application somebody else drafted. So secondary considerations allows me to introduce more facts and control the narrative more than I could, because I can't draft the application. So that's why it kind of appeals to me. And like I was telling everybody else, every rejection you have will have obviousness in it. You're going to have obviousness there. So you're going to have to deal with this going forward all the time.
Yeah, and I think that's a good way to put this. It does allow you to control the narrative to the extent that it's possible. And we're going to come back to that. Carrie, your initial thoughts.
My initial thoughts on obviousness generally are to not cite case law, especially if you want your examiners to be happy with you. Really stick to your claims and what the prior art teaches, and just don't bury them in case law. They will not like you for it.
Yeah, no, examiner. There's a place and time, not with the examiners. All right, so Wen, your initial thoughts. You wrote an article not too long ago on the secondary considerations specifically.
Yeah, please don't quiz me on it. I didn't review it before the session.
No, that's fine. I was just glad that you were available since you wrote the article.
Yes. Yeah, my initial thought is KSR has basically sucked the air out of obviousness with the obvious to try standard. It's somewhat like Alice in that there's really no metes or bounds for what you're going to say is obvious to try. It's a very subjective standard. So then you get to secondary considerations, and you're introducing evidence of, say, long felt need or commercial success. Sometimes I feel like you're just introducing evidence of why it would be obvious to try. So when you're introducing evidence of what you're supposed to be overcoming obviousness, I feel like within the framework of KSR, and then, I think to the examiner's perspective, you're just telling me why it's actually obvious to try this modification.
Right. Well, that's interesting. I guess I hadn't thought about it that way, and I wish you hadn't brought that up, because that complicates just about everything. But it does, I think, jive a little bit with what John, you had said, I think, during our pre-call. It's sort of a Hail Mary.
Oh, yeah. With the attacking the motivation, I think there's a lot of different responses from examiners. Some may shut down But generally, the examiners are probably not like, hey, you're right. This is a bad combination, right? I do think that there is a little bit with the patent office. The examiners probably don't want to withdraw their previous rejection. So even if you amend the claims to just shift the words around, that's probably a better approach, in my opinion, than saying, hey, this motivation to combine is suspect or problematic. I do, and I've heard other panelists today speak about 101 and 103 kind of mixing, and one of the things they talk about with 101 is ensuring that the claims embody the improvement to the existing technology or the improvement to the computer capabilities. And so that's one thing I really think about a lot is, make sure the claims embody the improvement to the existing technology or the computer capabilities. And the existing technology theoretically would be in that 103 rejection or 102 rejection. And my go-to move, probably when I get any office action, is to just really study the examiner's citations and see where they stretch the reference. That does happen. I'm sure you all know. Sometimes they might cite the same paragraph for two different elements, and you're like, wait a second here. And so that's one thing I would pick up on, and maybe it's nuanced. Maybe you have to make some claim amendments to really attack that, that element by element mapping. But that's kind of my approach.
Okay, great. Well, that is a good lay of the land, I think. So let's go back, Keith, and I want to start with you, because one of the things that has come up throughout the day, ever since it was brought up this morning when Drew raised it, and it's come up in all the pre-calls and everything, is interview. And I think you had mentioned that what a lot of us feel, patent office doesn't really take secondary considerations seriously, or it certainly feels that way. And the only way, I think you said that you've been successful, is during interviews. And can you tell us a little bit about that and elaborate?
Yeah, so echoing all the sentiment about interviews, I do miss the days of in-person interviews, because there you were able to control the room a little bit more than these telephone ones. So I'm still advocating for that. So every air form I fill out, I say in-person interview, and it gets denied every single time. But what you're using the interview for, I think this was mentioned earlier today, is you need to have a goal in mind. If you need to present secondary evidence, you need to, one, tell the client you're going to do this, maybe bring in the inventor with you to the interview, present like the evidence that you're going to submit, have the examiner or their supervisor sort of test that evidence during the interview, like what else do they need, and then you can go back and decide if you're going to submit all of that evidence. And so, the secondary evidence that we really focus on prosecution, the number one is surprising and unexpected results. That's the first thing to kind of look at. Skepticism of others, long felt need, those are going to be there as well. The hardest one in prosecution is commercial success, partly just because of the timing. You're only 20 months from when you filed the application, so it's really hard to have commercial success in 20 months. So you're really looking for that long felt need, the skepticism of others, and you're trying to convey that to the examiners. This is the information we have. How can we present these facts to you in a way that can overcome this obviousness rejection?
Yeah. And John, I think you had mentioned something about talking about commercial success too, because that's the one that everybody really always tries, but it really doesn't work all that well.
Yeah, well, I think we were talking about that. There was a Federal Circuit case.
Yeah, very recent.
Yeah, this month, I think 2 weeks ago, the WeatherTech case. I think the official name is YITA. But that case, there was 2 IPRs, and this is about Nexus, and basically they were both about vehicle floor mats, and they had this feature of close conformity of the vehicle floor mats to the foot floor well in your car, and basically the PTAB correctly decided one of the cases because the claims didn't even have this close conformity in there. So they did not find the secondary considerations persuasive, and the PTAB affirmed it. But in the other case, it did have the close conformity in the claim, the subject claim, and the The PTAB said this is persuasive, this is not obvious, and it was appealed to the Federal Circuit, and the PTAB had said, well, you know, there is evidence of industry praise. That's what they had said, that this feature, they had argued three: industry praise, commercial success, and long felt but unsolved need. And basically, the lower court, or the PTAB, had said, well, this close conformity is part of the claim combination of features, and so you know, they clearly have shown this nexus. And the Federal Circuit said no. Basically, this one feature that drove the industry praise actually was known. And they said, and they highlight this in the opinion, it's not well known, it's known. And so, you know, my takeaway from that case is well, the prior art governs the nexus for the secondary considerations, and more specifically, whatever the examiner said was obvious, that has to be part of the nexus. So if the examiner says that the close conformance is what we're using to make it an obviousness rejection, that has to be part of the nexus. If the close conformance was part of the primary reference, you know, that's what happened in this case, and it was unsuccessful argument.
It seems to me, and you know, maybe I can get, you know, when maybe you have thoughts on this, but it seems like ever since the Federal Circuit in Apple versus Samsung said en banc that secondary considerations are not an exception, but they really are a part of the inquiry, that they and everybody else has been trying to undo that and kind of relegate secondary considerations to the we don't do secondary considerations here. You know, like I can't do the head bob, but you know, it's like snap, snap, snap. Heisman, we don't do secondary. What's going on? I mean, is it they always say nexus, and to me, once they throw up nexus, it's like, oh, here we talk about subjectivity of obviousness. The subjectivity of what is and what is not a nexus just is mind-boggling to me.
Well, I would assume at the prosecution phase, its sort of lack of success is that probably is just more work. You've just introduced a lot more work to the examiner, and it's a test, and it's a weighing of, it's a factual inquiry that they don't have to do very often, with which there's no set maybe guidance as to how they're supposed to approach a set of facts. So maybe especially for junior examiners, they're not really quite sure how they're supposed to weigh the facts. And maybe for more senior examiners, it's just a lot more work. So maybe it's not received very favorably as a general matter at prosecution, for that reason.
Yeah, I think that's fair. I've had examiners tell me that when an attorney raises secondary considerations, they know they're right and the invention is obvious.
Yeah.
And it's like, that's actually not what the law says. You know, and I joke around, you know, I teach this patent bar review course, and one of the things that I joke around about is, you know, we say, okay, with a perpetual motion machine, it's the only thing that you have to go to the office with an actual working embodiment, you know, because they're done with perpetual motion machines, right? So, and I said, now let's say in 500 years, we've split the atoms, so who knows? I'm not going to say anything's impossible. Somebody comes up with a perpetual motion machine. What is the examiner going to do when that crosses their desk? We all know it's going to be rejected as being obvious, right? You know, and things like that just are not honest. And it seems to me that there's an awful lot of not honestness going on there. Carrie, you're shaking your head. You want to contribute to that, or you have thoughts? Am I being too harsh, or are they really just not interested?
I think that there is a general lack of interest in listening to the secondary considerations, because I do think that there's also a misconception that it's a Hail Mary, like, oh no, I know that it's obvious. And so I think that it kind of comes back to, we keep circling back to interviewing with examiners, and I think it's just so important to keep that line of communication open with them. I had a case 10 years ago where I had to submit an affidavit because we got unexpected results with a filter that combined 2 known elements but in an unknown way. And I bet I had 12 phone calls with that examiner on what should be in the affidavit and who should be signing it and all of these things. And if I hadn't had that communication with the examiner, I don't think it would have happened, because you just need to know, is this going to be enough for them before you go through the effort of putting this big, long argument on the record?
Yeah, yeah, no doubt. Now, Keith, that was something that you had put on your notes as well. How do you know when you're submitting the affidavit that it's got the right evidence or it's got the right testimony? And I think you even talked about it being biased versus unbiased. How do you go about doing this?
Yeah, and so, like, to your point about like how you take these secondary considerations and what's going on here, there's like a strategic ambiguous like level, like it's just obfuscation to the highest degree, because it'll say if you have a strong case of obviousness, no matter what your evidence is, you can't overcome that. Well, I don't know what a strong case of obviousness is. And then they say, well, if you have a weak case of obviousness, you can overcome it with secondary considerations. Well, you think I
But
should
that's not
overcome
the-
over a weak case of obviousness by just blowing on it,
Yeah.
right? It should just fall over.
It should, right.
I shouldn't need this. And so,
Well, and it's also not the law.
well, they find elements in bits and pieces of the law
Yeah.
and kind of come up with this idea. And so that's what makes it a little bit challenging. But like, so, you know, as you're going through this, I don't know, has anybody submitted secondary evidence at the prosecution level before? Just a few hands out there?
Yeah.
Yeah, so, you know, you're always going to run into the problem of every time you submit something, there's going to be an obstacle to submitting that data, because there's some level of untrustworthiness about your data that you're submitting. So like if you have the inventor sign the affidavit, well, that's untrustworthy because the inventor's now biased. So how do you show that the inventor's not biased in this situation? One is you got to make sure that the inventor says no conclusions whatsoever in their declaration. That's just pure factual, just fact after fact after fact. And then in your arguments, you say all the conclusions based off those facts. So it's almost like a litigation type strategy where you don't want to have the inventor testify to anything else beyond it. But they can always throw up the obstacle of, well, he's biased because it's the inventor. Of course, the inventor would want to say that. And then at the prosecution level, I've never found a client that's willing to pay for an outside expert to sign an affidavit. But that's the type of level that they're looking for to say, well, this is now unbiased, and that type of level. So there's so many obstacles and roadblocks just because they're not trustworthy of the facts that you're presenting them.
Yeah. Yeah, I mean, I guess, I suppose that's what it boils down. You would like to think that's what it boils down to. But I don't understand also why doesn't if it's not obvious, I mean, with KSR coming in, and there's really I know that the Supreme Court thought there were 6 different KSR rationales in addition to TSM. There's really one. I mean, if you read all the other 6, they relate to predictability of results or expectation of success, which is just saying predictability of results a different way. They all relate to them. You know, so if the invention is non-obvious, then why isn't there also secondary considerations? And if that's the case, then secondary considerations aren't just about undoing or overcompensating for the first 3 factors. It's like you can't, if you have them, it not only should weigh as you win factor 4, but you lose examiner based on KSR. Because if they're there, then it drives a knife straight through all the KSR rationales, unless there's a teaching suggestion or motivation. But that's not the way it plays out. And I don't understand why that is. I really don't. Because logically, you know, you could. This is a logic game to which there is a right answer, I think. Has anybody thought about any of this? You know, how do you weave or dovetail secondary considerations into the obviousness argument, or leverage the obviousness argument into secondary considerations, or kind of present it all at once? And I mean, what kind of conversations work with examiners?
Well,
Go ahead, Keith.
Yeah, I was going to say, one is you can't fall into this trap of saying, I'm presenting secondary considerations because you, examiner, have made your case, and therefore I'm in a bad position. You have to really convince them that all these secondary considerations are going to attack each one of those elements. It's the knowledge, skill, and the art. It's the combination of the references, what the references actually teach themselves. It's all pulling into this as well, so that they look at it as a whole picture. Because once they see it as, oh, I've won, and now you're trying to salvage something, then you've really lost at that point.
Right. Carrie, you look like you wanted to say something as well.
Oh, no.
No. Okay. Does anybody have John thoughts? Because you used to be an examiner. So, what worked with you, and what do you find works for you?
Well, we used to say reasonable minds can disagree.
Yeah.
No, I think that generally, like I said earlier, is just, look for weaknesses in the examiner's element by element claim mapping. I think that's the best approach, because you can say, well, you're taking the position that, this teaches feature X, but this feature X doesn't actually correspond to what's in that paragraph you cited. I think that's the best way to attack it. And sometimes even you have to pull something in from the specification. And some people on the earlier panels, I think maybe even all of the panels, have really talked about spending more time on the application drafting stage. I think that, that gives you more arrows in your quiver, and it gives you more wiggle room when you maybe do get stuck with an application. So that's kind of my approach. I mean, there are other ways to attack obviousness, rejections. I have argued defeats the intended purpose successfully before. And I do also attack whenever they take common knowledge or official notice. They'll say, I take official notice, or this is common knowledge in the art. So there's an MPEP section that kind of lays out how to traverse that, and basically you demand that any next office action supports their position with evidence. So I always attack official notice.
Yeah.
And I think it's important, too, to not bury examiners in arguments. I think you were talking about this, Keith, in our pre-call, is pick one or two of your best arguments. And I don't know if there's a way to intertwine both of those, that it's not obvious and you have secondary considerations, because I think you're kind of either arguing one or the other. You can try to do both, but I think it gets a little messy. I think generally if you pick your best argument and stick to that, the examiners are usually happier and you usually have more success.
I guess. I mean, I don't know.
I don't know if I like that answer, but
I mean, we're describing something that, to some extent, is a little bit indescribable, because I think if you got most examiners, you had a couple beers in them, and they were at the trademark bar, they would tell you, "Oh, we don't do secondary considerations." And I think all of us have probably been told that by examiners at one point in time.
Well, and saying
Go ahead.
case law, don't even call it secondary considerations. Just call it the evidence that helps them show that it's not obvious.
See, I agree with that, because
once you start saying these key words,
right,
then my experience is once you say a key word like teaches away, all of a sudden you're rejected forever.
right,
You can't ever get away from that. Once you say secondary considerations, then this whole thing comes into play. If you just kind of describe it a little bit more about why this is useful, the examiner has a little bit more comfort level with it.
right, and frankly, it's if there's long felt need, I mean, that qualifies as a secondary consideration, and it also addresses at least some of the KSR rationales. If there's skepticism, well, that means there wasn't predictability. So I think you're doing double duty. So I like the suggestion to just attack with the weapon that you have, whatever one it is, and don't attack the obviousness rejection and not wave a secondary consideration flag. Would we all agree on that?
Yeah. I think under the current rules, technically, when we introduce evidence, the examiner is supposed to rebut, right? Technically, that's
They're
supposed to
supposed
happen.
to
They never
consider it.
rebut.
Well,
You're supposed to just
technically,
consider it.
Yes.
well, actually, they don't even consider it. But I think technically, you submit an affidavit. The rule is, the examiner is supposed to accept it as true, and they don't. But how does the examiner? Of course, the rule has to be that they accept it as true, because the examiner doesn't have any subpoena power or ability to go out and look for other outside. Now, if you wind up telling a lie and it's not true, then it's going to come back to bite you. Our registration number comes with an awful lot of trust, But so when I also asked you if you were interested in sort of co-moderating this panel with me,
Right.
because you're also very good at doing that as well. So do you have any questions for the panel, or even for the audience if you want to get the audience involved? It's up to you.
Yeah, I guess, when you decide to introduce secondary considerations, admittedly, it's probably not your plan A. And you have to, at some point coordinate with in-house and have that conversation that, hey, we may need secondary considerations. What do we got? So, I am interested in hearing what the panel has to say about when you decide, when do you make that call? When do you say, hey, we're in trouble? When do at what stage of prosecution? Because it's probably not the first office action. You want to get a little bit into it and feel that this is probably needed at this point. So I was wondering, maybe you could share some thoughts on that.
So for me personally, once I got that second rejection
Mm-hmm.
and I knew that it was just, we weren't going to get anywhere, I reached out to the client. Do you have any additional evidence to combat this obviousness argument? And thankfully they did. But I think you're right. I don't think it would be in the first go around. And you may even scare the client away if on the first office action you're like, I don't even know how to address this obviousness rejection.
Yeah, kind of two thoughts here. One is if you get your client involved in every obviousness rejection, say we need to have secondary considerations for every single thing, you're going to wear the inventors out. They're going to be really exhausted by the demands, and they're going to be like, well, what's the purpose of our attorney if he just keeps coming to us or about secondary considerations all the time? So you really have to pick and choose the cases where it's going to make the biggest impact and where you think you have the strongest evidence behind it. And that's not going to be clear initially, but you'll see that going through the prosecution. So the first one may be difficult to bring it up, but if you have it in your application, and like I said, I don't prosecute many applications, I draft, so I'm sort of at the mercy of everybody else. But if you have data, maybe you can use the data to say this is surprising and unexpected. It's already in your application. If your background, and I know we don't want to write too much of backgrounds to admit prior art, but if your background talks about a long felt need, bring that up to the examiner. It may not be in your background, maybe your detailed description, bring that up. And so you can bring that up earlier before then you go back to the client and say, now we need to spend a lot of money, now I'm going to need resources, and then that might give the client a little bit more comfort level in how you're handling it.
Yeah. John?
I was just gonna say I've been talking to Keith a little bit the last week or two, but sometimes more casually you might bring up the secondary considerations, maybe even not even with an affidavit. You don't have the evidence, but you're just saying this is unexpected or something like that. So, but as far as asking the client for an affidavit, like we've talked about, I mean that's kind of like 4th and 25, like a Hail Mary. If the application is stuck. That's probably when I would do it. So rarely.
And I think you don't even have to come in with the evidence right away. You can just approach the client with, hey, we're facing this piece of prior art. Could you give us your feedback on it? Because they may look at it and go, oh gosh, we're stuck. We can't do anything. Or they may have another idea that you didn't think of. I don't know if you guys ever do, rarely, but sometimes I'll go back to the client with the prior art and say, hey, can you give me your feedback on this? And sometimes it's just helpful.
I found what's useful if you give the prior art to the inventors and they laugh at you, then you know that's not a really strong obviousness case. And then you can kind of go forward and say, okay, now we can submit secondary evidence because it's so weak. I don't know if that's how you test a weak obviousness case or not, but I found that sort of skepticism by the inventors really goes a long way to convincing the client that now is the time to submit secondary evidence.
So when you ask the question, so I'm going to ask you to answer your own question.
Okay.
Because I know you do prosecution, and you do primarily in the computer space, right?
Yeah, these days, but I still do a lot of mechanical and AI.
So what do you think?
My most salient memory of secondary considerations didn't work. So, unfortunately, most of the time it really doesn't. But I think what it did was when actually the client told me, hey, this happened during R&D. This is what we were faced with, and this is the obstacles we were faced with. And what you learn is that it's never really on the money, the categories of unexpected results or long felt need. It's your job to sort of frame the facts that they give you and try to move it towards one of the factors they have, because what your client is going to give you is a bunch of stuff that happened, and you're just going to try to figure out how to timeline it, and then whether you need the inventors to come in and to make write a declaration, or you help them write the declaration. But it's going to be your job ultimately is to frame it within one of the categories of secondary considerations, because your client isn't going to gift wrap it for you.
Right. Well, one of the things too, it seems that secondary considerations can be difficult in the prosecution, because the invention has just really been made. Assuming this is not like a child of a child of a child, or like the long family history, it's relatively early on in the invention ecosystem and life cycle. But during litigation and then in the PTAB, that's sort of when I think that it becomes more alarming that secondary considerations are not given more consideration. And what I'm told by a lot of people I talk to, including some judges and so forth, is it's the nexus. It's always the nexus that's missing. It's you proved A really well, but what you needed to do is prove C, not A. But how, Keith, and let me start with you, Keith, because I know that one of the things that we talked about during our pre-call was how do you draft an application with an eye towards potentially leaving open secondary considerations, or even making that possible or more possible. And not that we need to get into the litigation end, but if you don't have it in your application, you're not ever going to be able to rely on it in the IPR or litigation. So how do you make sure that arrow is available for your litigators later on?
Well, first in the chemical arts, data, and examples. If you can't file without that. You're going to need that, and that's always going to be the surprising, unexpected results that you're going to be relying on. That's why you have the data to start with. The second aspect is in figuring out, ask the question, why has no one else ever done this before? Most of our inventions that we deal with are incremental improvements, so it's going to be challenging to really draw out this really big, long, unfelt need, because it's an incremental improvement. So maybe the long felt need doesn't work there, but recognize it, but characterize the statements of, well, why has no one ever done this before? And pull that out, pull that into the application, figure out where that fits, because once it's in the application, then you can use it. Now, it can be used against you, so you got to be careful about those statements, and you got to be judicious about your statements. But that putting everything there at the beginning can really help, because if you're coming to an application that's bare bones, doesn't have any description about why they are doing it, you can't figure out what the invention is, and you're trying to introduce all this long felt need, there's going to be a big skepticism about why that wasn't there in the first place.
So are you, what I'm hearing you is like you need to be thinking about the nexus and the predicate while you're writing the application, and not later on. I like that.
Yeah, like Tara said, it was like if you have a reference number in your drawing and it only has one word, it's the same type of thing. If you have one feature and you don't have any reason like why you have this feature is for whatever, you don't describe it, what are you going to do when it comes up later? Why is that feature important?
Right. Carrie, I see you're shaking your head in agreement. What's going through your mind?
The why, I think, is so important. I don't think there's any silver bullet that's going to encompass everything, but when I hire new attorneys, I tell them that everything needs to have three things in their spec: what it is, what it does, and the why or the how. And if you just have that one sentence for your element, that's not going to be enough. You need to have, and maybe not, if it's a speaker and an amplifier, you don't need to say what it is and why it works and what it does. But you need to have that why so that you can fall back on it if you need to.
Yeah, very critical. John, your thoughts on?
No, I totally agree with everything. I mean, I think, I think everybody, this whole day, everybody's stressed, spending a little more time on the specification and kind of digging in, how something works. And, it does show up in the 101, in the American Axle case. One of the problems was they didn't explain how they tune the mass and stiffness of the liner. I know everybody's like, hey, this is automobile manufacturing, but that was what they really honed in on. That was why it was an abstract idea, was they didn't, maybe if they had, done things a little differently or spent a little more time on the specification, maybe a different result.
Yeah. No, I think that very well could be true. I think time spent on a specification, it never goes to waste. Wen, do you have any other questions for either the audience or for the panel?
Well, maybe perhaps for the in-house in the audience, if they keep a book of secondary considerations, or do they know, do you keep track of commercial success and the like? Perhaps it would be interesting for
So we have
outhouse people
a
like
number
me.
of in-house folks here. So maybe by a show of hands, how many of you track any of the secondary considerations and have them available? Or let's just answer that question. How many hands went up? Like a couple hands. And how many of you, if it becomes necessary to provide it, would be willing to provide it even if you had to create it? Okay, a lot more hands went up that time. So now what should they be creating? What should they be tracking? What is, in your experience, the most powerful? Because everybody always likes to point to, well, this is, it's being copied, they were licensing it from us, or we have commercial success, and a lot of those can be much more difficult to tie to the invention. Where are you seeing the most success across your portfolio of cases?
Unexpected results.
So the same thing, Carrie, that would get you through KSR.
I think so, but I'm not sure.
So, and that's a good question. So
Yeah.
is the unexpected results, and I've often wondered this because it seems like it's redundant otherwise, but if it's not redundant, and one arrow strikes all the way through KSR and straight into secondary considerations, unexpected results, does it mean different things in the same terms in the basic obviousness inquiry versus secondary considerations, or is it really the same one? And I don't know that I've come to any conclusion. I mean, I know what I think it should be, but I don't know that this has ever really been discussed.
I was just telling them before we jumped on stage, I don't know if my declaration that I filed before that would uphold right now. I don't know.
Yeah.
I think
John, go ahead.
I was just going to say, with that Federal Circuit case, it seems like, well, you kind of have to do two things. One, the industry praise seems like maybe it's better because it's explicit compared to the commercial success, because that could be attributed to the marketing or your brand, your brand equity. But what happened in that case was, one, they argued, multiple considerations. So it's not just one secondary consideration. It's like all three of them tied to this feature. But then the second thing you have to do is you have to, and this is kind of a moving target, is that feature that you do have the evidence for secondary considerations, that actually has to be part of the 103 analysis. That's the nexus. So it can't be part of the primary reference and be known. And so it's like, well, the secondary considerations for today may be different than if you have a different rejection coming up tomorrow.
So, I know you raised this and you mentioned this during the pre-call, and we've shared some emails going back and forth about this. And I guess I really didn't understand what it was that the Federal Circuit might have been saying, because I never really understood secondary considerations to be limited to, well, you have to rebut this piece in particular, whereas no, there's a combination here, right? And if the nexus applies to the invention, the commercial success, you can't, so I got to show commercial success because of a certain feature or subset, and not just for the the innovation as a whole, seems to go contrary to obviousness law, and that's probably not surprising, right? Because all this stuff seems to, for every statement you can come up with, there's going to be another statement from the Federal Circuit that's precedential that contradicts it. You know, obviousness is supposed to be about a totality of the invention, and we know that the sum of the parts can be greater than the whole. So the synergy cannot, you know, I can take that A, which is well known, and B, which is well known, and mix them together. And the fact that both of those are well known doesn't mean that when you mix these things together, that the combination is well known, particularly if it has some unexpected or synergistic effect. But so I guess I don't know anymore where you're supposed to focus the nexus. And maybe that's the beauty of it from the examiner's point of view or from the judge's point of view, who maybe, and we know there are some judges who just don't like patents, and it's fine. It's a philosophy I disagree with. But it gives them the ability to just very subjectively do some hand waving, I think. Agree, disagree? Am I being too harsh? Am I right on? Am I not being harsh enough? What do you think?
I think it's very subjective, and it allows them to just do hand waving, as needed. And that's why one thing I didn't hear yet today, and I apologize if I missed it, is I actually try to get the supervisor involved very early on in the process. Some of them don't like it, but depends on how you say it. If you say, hey, I really am eager to get this case allowed, I want to have the supervisor on the first phone call. So then you're not waiting until the junior examiner doesn't respond to you and then you're having to go over their head. You have them involved right from the get-go, particularly when you have a difficult obviousness rejection. You don't want a newbie who has no idea what they're doing and then has to go to their supervisor and then come back to you. So the first thing I do when I get any office action is I flip to the last page. Does this person have signing authority? If they don't have signing authority, I want their supervisor on every phone call that I have. And it just makes the whole process a lot easier.
Are you able to accomplish that?
So far.
Okay, that's an interesting question for the audience. How many of the audience have tried that and not been successful to get the supervisor involved?
From the initially or at all?
At all.
And is Bob Stoll here, still in the room?
Yeah.
So discretion, no discretion, what's the rule?
I have always had the supervisor involved if it's not a primary. So
Same.
sometimes it's a primary because they serve as a supervisor. Sometimes it's a supervisor, but I've never been refused because I threatened to call Drew.
Well, okay, so that was the next question. So is that, Bob, is that because you're Bob Stoll?
No, it is not.
But are you sure? I mean, how would you know?
All of his friends get that.
Right. Oh, yeah. Right. It's not because you're Bob Stoll. It's because you're a friend of Drew. Right. No, but I mean that's an interesting question. You know.
True, yeah, so I think, Gene, you know this, like, for me, I think supervisors should be called in.
Mhm.
And you know, I was voiced up in the previous panel when there's concern. People should not hesitate to reach out to the supervisor, and I'll take it a step further than Bob did. Definitely when there's a junior examiner, there needs to be somebody in there with signatory authority. That's the right of the applicant to request that.
Yes.
And that
Yeah.
should be, and that could be a supervisor, could be somebody delegated by the supervisor. But even if it's a primary examiner, I think it is appropriate to ask for the supervisor to be in there. That does get a little bit more sticky, I get it, but I think that's appropriate. It bothers me to hear people are not having success with that because I think the supervisor should be receptive to that. Quite frankly, and I've got folks in the room who will confirm this, because we did it recently. If you're not getting the SPs, if the SPs aren't being responsive, then you take it to the next level, and that's the group director.
Yeah. Yeah. So, and I know we have some chief IP counsel in the room, and I know we have a number of chief patent counsel. I'm going to ask a litigation question. I mean, how many of you have been involved in cases where the judge has required that the person who has signatory authority or settling authority either be involved in the mediation or be reachable the day of the mediation? Right. I mean, that's like as common as, otherwise the mediation is just a farce, right? So I don't understand why it should, and it is, I suppose, for some examiners, but why is it a threat to them when you have nothing to say about whether this case gets allowed. I want the person in the room who actually can decide whether this case gets allowed. And I know that that's an affront to some examiners. It just bothers me that it is. It shouldn't be. We've all been that person. We've all been the person carrying the bags, And now we're not the person carrying the bags. And now we're training the next group of people, and they don't have authority. So why should it be a problem that this person who doesn't have authority have a supervisor there? And I think, John, you've played the examiner, you've played the attorney. Do you go to the mat sometimes to fight to make sure that you're actually talking to the person who has authority?
It's case by case. I'll say a couple kind of, counterpoints is, one is that the examiner may have a primary examiner mentor. So the supervisor may not necessarily be training the examiner. And so, you may ask for that primary examiner mentor, or kind of, I guess I don't want the examiner to have a bad attitude.
Right.
So that's one of the things I think about. Now, sometimes you do have to, go to the director or the ombudsman in rare cases, but I kind of follow a procedure where I use the AIR form, which everybody talks about, and I think they're supposed to get back to you in like 24, 48 hours. And I think and they're pretty good about that generally, or I start calling them every day. And then I usually have an interview agenda, 24, 48 hours before the interview. And a lot of times what I've noticed, even for the junior examiners, you send that agenda and they're taking it to their boss. Mm-hmm. And most people in the world want to do what their boss wants them to do. And so I don't necessarily always drag in the supervisor. I kind of give them a little rope one time, and then if I need to later. Yeah.
And how is this strategy affected by the fact that you may be dealing with an examiner who hasn't allowed a patent since Alice? and I know that not all of you work in that particular space, but I know, in 1600 there are problem art units, in 1700 there are problem art units, in 3600 there are lots of problem art units. And I know I'm still told today that examiners are telling some people, in a moment of honesty, because they know they can, I haven't allowed a patent since Alice, and I'm not going to start with you. And it's like, okay, well, wait a minute, let me check my watch. This is 2023. Alice was 2014. You haven't issued a patent in 9 years. And I always hear patent attorneys say, well, I don't want to spoil the relationship and I don't want to upset the examiner. It's like, pal, you have no relationship with an examiner that hasn't issued a patent in 9 years and still has a job. This is sort of your space a little bit, right? Or at least do you want to answer on tape, or do you want to not?
What's the question?
What do you do? What do you do?
I think you just take it one step at a time. You see if there's a little room. I think initially I would go the way John has said, is that, don't force it right off the bat if they seem hesitant, because I've been a young associate and I had an examiner say to me, wow, your registration number is really new, and can I talk to somebody with, who's going to say yes or no to me on the phone if I propose this,
Yeah.
So I kind of say, all right, if he doesn't want to, let's just give him a little space. But you just play by ear, I would say. There's no real textbook answer. I think if you get to the point where you're like, all right, let's just go for it, and who cares what he thinks right now, you could do that. But in the beginning, I would give him a little room in the beginning.
Yeah. So Keith, let me ask you about that, because you work in the more chemical areas. Which I'm not familiar with the allowance rates in those. Are they good? They bad? They average? They below average?
Pretty average.
Pretty average. So you probably don't come across the examiners, at least yet, that are, why don't issue patents because.
No, but there are some challenging examiners out there.
Yeah.
And I think kind of turn it back to secondary considerations with the supervisor or mentor. And just to your point you made earlier, if reasonable minds can disagree about the evidence, getting two people in the room
Right.
and trying to convince one of the two might go a long way, as opposed to having one person that then has to convey your message to their supervisor. My sense is when you have secondary considerations, a lot of people are going to be looking at this type of evidence.
Right.
And so you want to have that best evidence. You want to have the most people there buying off on that evidence that you're presenting to
And that sort of goes along with what John Roget said earlier about, don't be afraid to appeal as a strategy, because sometimes examiners have an allowance bump, even with the notice of appeal. And others will have the bump if you file the appeal brief and so on, because there's more eyes on them and they're getting more people in the room. And hopefully you're engaging in the pre-mediation or the pre-appeal mediation. And so I do think that makes a lot of sense. Go ahead, John.
I just wanted to, with the one-on-one stuff you talked about earlier, I think one of the things that's really helpful that the USPTO does really well is their patent eligibility guidance, their webpage with all that. I think there was like 42 examples from 2019 and before. And I think those are really helpful. So maybe you can, like, if you're doing an AI training claim, you can look at how they did example 39, which was the training of the image correction data. Or if you're trying to, do less memory, look at the RCT Microsoft case or something like that, and kind of see what did work. Maybe, I know it is tough when you get into the business methods art units, and a lot of people try to avoid that. And I've seen people talk about, I think actually Schwagman had a webinar about trying to avoid classification into certain art units, 3600. But I do think the USP2 has a lot of good examples, and then also the Federal Circuit has found some cases patent eligible, so I look at those.
some cases. I love how you say that, and then everybody's just knows what you mean, knows that you're right. But at the beginning of our legal career, if somebody had said that, they would have been laughed at. What do you mean some cases? Everything's patent eligible. I mean, how have we gone astray? And we're coming up close to time. We have probably about a few more minutes at least. So what I'd like to do is I'd like to ask each of you if you would like to kind of wrap up with your key takeaway point. The conversation went pretty quick, but Carrie, let's start with you. What is the one thing you hope people remember about obviousness or secondary considerations or tactics?
I would say just communicate with your examiners, and by no means am I forcing anyone to do an interview, so if it came off that way, I don't want it to be that way. But when you have a junior examiner, use this as an opportunity to guide them and not be adversarial with them. Be on the same side of the table with them. Hey, I noticed you don't have signing authority. Would it be okay if we had your supervisor or your primary on the call too, so that we don't have to go back and forth, and so that I don't have to explain my argument to you and then you have to explain it to them? I think it's just so important to be as kind as possible to examiners. I don't know if that's necessarily for secondary considerations.
No, it's
but
sort of like, just don't tick off the person who's ultimately going to decide your case.
Exactly.
All right, great. Thanks a lot, Carrie. Keith, what is your takeaway message from today?
Yeah, I mean, if you're going to use secondary considerations, and it should be part of your obviousness rejection, you should be really precise about what those facts are going to be that backs up those secondary considerations. Precise, but don't need to label them. This is long felt need. This is unexpected results. And present those facts. Be very factual. Don't submit a huge amount of volume. If you submit a lot of volume to try to hide the lack of facts, people are going to see through that really quickly.
Great. Thank you very much, Keith. John, your final thought for us here today.
I think the name of the game is in the claim, and your claim should embody the improvement over the existing technology or computer capabilities, and that'll solve a lot of your issues, and with detail how you did that in the specification.
Great. Thanks a lot, John. And last but certainly not least, what is your takeaway from this discussion?
Yeah, there's just no right or wrong way. I think, as an attorney, you may be afraid of making a mistake, or, oh, I said the wrong thing, or this was a bad way to go, I should turn it around, or something. But, I feel like with obviousness, they have room to maneuver, you also have room to maneuver. And you could play a lot of things by ear and just see how it goes, have more discussions with the examiner. You just have a lot of options, and to not close yourself up.
Yeah. Yeah, and I guess secondary considerations remain a bit of, as you said, John, a Hail Mary, for reasons just, the reality of it. The reality of it is that it's a tough road to move forward with, but it is supposed to be available to us, and I think the best advice to take from what Keith you pointed out is you really have to keep it factual, keep it precise, and make sure you're trying to tie the nexus, as John, you pointed out, to the kernel that was in the obviousness rejection. And you probably have a lot more success if you do it that way. But all right, thank you guys. I really appreciate it.
Thank you, Gene.
Thank you.